by Senator Antonio Sani F. Trillanes IV.
In the name of the Father, Son, the Holy Spirit, Amen. Almighty God, we thank you for all the blessings that you have bestowed upon our country and people. We praise you and we worship you. We humbly submit our lives to you and ask for forgiveness for all the wrong things we have done to our fellow men and to your creations. We seek your wisdom and divine light as we try to live our lives in accordance with your will. In Jesus' name we pray. Amen.
Amen. The Secretary will now please call the roll of Senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Escudero, Estrada, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President.
With 22 Senators Judges present, the presiding officer declares the presence of a quorum.
Mr. President.
Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the May 25, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the May 25, 2012 Journal of this Senate sitting as an impeachment court is hereby approved. The Secretary will please call the case before the Senate sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Chief Justice Renato C. Corona.
Majority Floor Leader.
May we ask the parties or respective counsel to make their appearances, enter their appearances, Mr. President.
Mr. President, good afternoon. For the House of Representatives Prosecution Panel, same appearance. We would like, aside from that, we would like to add the appearance of the Speaker of the House. We are ready, Your Honor.
Noted. Defense.
For the defense, Your Honor, the same appearance.
Noted. Before we proceed, I just want to make, I would like to clarify something from the defense. And I address this to the Chief Defense Counsel. I understand that there was an interview done where you were involved this morning and that you indicated your determination to elevate the result of this proceeding to the Supreme Court. Is this correct?
I did not have any interview, Your Honor, with anybody this morning. In fact, I woke up about 9 o'clock already because of the preparation of my paper, Your Honor, in connection with the argument.
I got this information, transcript of interview of former Justice Serafin Cuevas with Tueng Salvacion of the CBB.
Mr. President, most probably yesterday.
Monday.
Yeah.
Sunday yata yan.
Maybe
Sunday, Your Honor.
Sunday.
Yes, not this
yesterday.
morning.
And I will quote what the defense counsel said. Quote, "We have no other alternative but to resort to certiorari. I have asked a petition for review, questioning the validity of the actuations or the proceedings before with the impeachment court and necessarily with a motion to nullify the entirety of the proceedings that took place therein." Yung pong walang appeal, hindi po kami totohanang sumasakay doon sapagkat hindi naman nakalagay sa konstitusyon iyon. Ang nakalagay lang the moment the Senate convenes as the impeachment court shall continue the trial. Wala po naman sinasabi ang desisyon shall be final and non-appealable. Wala po talagang ganon na nakalagay sa saligang batas. We respect your position, but I just want to remind you that our reading of Article 11, it's provided that the Senate shall have the sole power to try and decide all impeachment cases. I just want to put that into the record.
Yes, Your Honor. If the question refers to the interview of Weng Salvacion ba yun? I admit, Your Honor, that last Sunday, I think, in her program, I was interviewed, and I made those statements, Your Honor.
All right. Majority Floor Leader.
Mr. President, a member of the court would like to raise a point of order. May we recognize Senator Miriam Defensor Santiago?
The lady senator from Iloilo.
Thank you. The Constitution provides, and I quote, "Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold any office under the Republic of the Philippines." Thus, the Senate can impose a lesser penalty, like censure, reprimand, fine, suspension from office, or the like. My question is, in case of conviction, how shall the penalty be determined? I humbly present this question both to the presiding officer and to our colleagues, not necessarily to be answered immediately, but to be disposed of at the discretion of this court. Thank you.
Thank you. Majority Floor Leader.
Well, perhaps, Mr. President, we can take it up after today's session.
Yes.
Mr. President, with each side having rested their case, we now open the floor for the parties to present their respective arguments. Under Rule 20 of the Rules of Procedure on Impeachment Trials, which I now quote, "The final argument on the merits may be made by two persons on each side, and the argument shall be opened and closed on the part of the House of Representatives. And as previously ordered by the court, each side will have a total of 1 hour. The final argument on the merits shall be opened by the House of Representatives, and after which the defense. The House of Representatives shall then close the arguments for a period not exceeding the time not used in their opening statement." With that, Mr. President, the court is ready to hear the arguments of the parties. I move that we recognize Representative
Mr. President.
Tupas.
The gentle lady from Iloilo.
Point of information, please. Since it's not provided for in the rules of the Senate, may I please inquire whether the senator judges are allowed and then expected to examine those who will present the closing arguments or not? I don't care really any which way. I just want to know. Thank you.
Majority Floor Leader.
We will submit it to the body later after the arguments, Mr. President, but the tradition is that, well, in the courts, is that it may be allowed depending on the judge, but in our case, we have not taken that up formally. We can probably take it up also, as I said, after the arguments. So with that, taking into consideration the point raised by Senator Miriam Defensor Santiago, may I move that we recognize for the presentation of the arguments for the House of Representatives, Representative Tupas.
Thank you.
The gentleman from Iloilo.
If Your Honor,
Yes, but may I just speak? May I just
sige,
speak first? Mr. Senate President, earlier, the prosecution conferred with the lead defense counsel, and we agreed that the prosecution will speak first, then the defense, then the second speaker for the prosecution, then the second speaker for the defense, then the prosecution will close the argument, to be delivered by the
But
third speaker.
under our rules, the opening argument is supposed to be done by the prosecution.
Yes, sir. That's why we will open it. But the presentation will be alternate. Meaning, we will open it, first speaker from the prosecution, then defense, then prosecution, defense, then prosecution will close the argument.
So you have 3 times to speak, 2 times for
Yes, sir.
the defense.
We admit, Your Honor, and we really have agreed on that, subject to the approval of this honorable
Is
court.
there any objection from the members of the court?
We have no
chair
objection,
is none. The motion is granted.
Thank you, Your Honor.
Proceed.
Mr. President, permission to begin the closing arguments for the prosecution. May I ask permission? Thank you. Mr. Senate President, honorable members of this Senate Tribunal, Mr. Speaker of the House and Majority Leader, fellow members of the House, counsels for the defense and prosecution, my fellow Filipinos, good afternoon. Like all defining moments in our nation's history, we are once again called upon to make a choice between right and wrong. The day of reckoning is here. Everyone has said his piece. It is now time for us to make sense of all the pain that this impeachment trial has caused. Let it be clear that we meant not to destroy a man, but to destroy the evils that plague our system. We do not rejoice over the fact that in the process, deep wounds were inflicted. But sometimes, great pain must be endured so that genuine healing may begin. Today, we lay down before the Filipino people and this impeachment tribunal the truths that have come out of these proceedings. Tungkol saan po ba talaga ang impeachment trial na ito?
Excuse me, Counsel. At this point, I would like to inform the court that if there is any member of the court that wishes to ask clarificatory question about the statement of any speaker here in the course of their argumentation, you raise your hands, you will be recognized by the majority floor leader, and you may posit your clarificatory question, and you have 2 minutes, not more than 2 minutes.
Is that after the delivery of the speech, Your Honor?
Well, maybe if that is the pleasure of the House, after each speaker has delivered his speech. Okay, so order.
May I proceed now, Mr. President?
Proceed.
Tungkol saan po ba talaga ang impeachment trial na ito? More than anything else, this impeachment trial is about our people's aspiration to regain the greatness that was once ours. For how can we inspire greatness in our people if it is not greatness that sits on the thrones of power? We Filipinos come from a long line of maharlikas and heroes with rich and proud heritage. Our history is lined with honorable men and women who suffered so much in the name of country. 70 years ago this month, Chief Justice Jose Abad Santos died in the hands of the Japanese rather than betray his country. 50 years ago, former Chief Justice Manuel V. Moran, who was offered a chance to return to the Supreme Court, refused a midnight appointment rather than dishonor himself. Today, we have a Chief Justice who has been impeached and now faces judgment before this honorable tribunal. Obviously, we took a wrong turn somewhere that led us to stray from the path of greatness. That is why On December 12, 2011, an overwhelming majority of the members of the House of Representatives, 188 in all, heeded the people's call for truth and impeached Chief Justice Corona for culpable violation of the Constitution and betrayal of public trust, a new ground for impeachment under the 1987 Constitution. On January 16, 2012, the prosecution commenced the presentation of evidence that cast serious doubt on Respondent Corona's moral fitness to remain as Chief Justice. Chief Justice Renato Corona must answer to the people for his wrongs. Sa 8 articles of impeachment na inihain ng Kamara dito sa Senado, hindi na po namin kinailangan pang i-present ang 5. Dahil sa 3 articles pa po lamang, kumbinsido na kami at alam namin kumbinsido na ang taong bayan, hindi na karapat-dapat manatili sa pwesto si Chief Justice Renato Corona bilang maestrado ng ating bansa. Our quest for truth has led us to many truths about the Chief Justice. It has led us to the truth that the Chief Justice failed to disclose to the public his statement of assets, liabilities, and net worth as required under the 1987 Constitution. It has led us to the truth that he lied about his assets in his SALN to conceal his enormous wealth. It has led us to the truth that he peddled his position of power in exchange for material gain. It has led us to the truth that his loyalty does not lie with the Filipino people. On the whole, it has led us to the truth that he is in public service not to serve his country, but to serve his own ends. Article 11, Section 17 of the Constitution requires all public officers and employees to submit a declaration under oath of assets, liabilities, and net worth, with an additional requirement for the highest officials, including the Chief Justice, that the declaration shall be disclosed to the public in the manner provided by law. A prime objective of the framers of the Constitution in requiring SALN was to strengthen the accountability of all public servants and to root out the perennial problem of corruption and abuse of power in government. To be meaningful and effective, the SALN requirement must be complied with truthfully, completely, and accurately. It must be complied with in good faith. No amount of denial, no lame excuse whatsoever can stand against the best evidence itself. The SALNs of the Chief Justice from 2002 to 2010, executed by him under oath, year after year after year. Respondent Corona has repeatedly failed to truthfully and accurately disclose in his SALN numerous assets and real properties which he and his wife own. Luxurious condominium units and huge parcels of prime property in Taguig City, Makati City, and Quezon City. Instead of declaring the acquisition cost of the real property, the Chief Justice declared only the fair market value for taxation purposes, which does not serve the purpose of and has nothing to do with the computation of the net worth in the SALN. The Supreme Court declared in the case of Republic versus Andigan Bayan that it is the acquisition cost of the property that must be charged against respondents' lawful income and funds. And what about the Chief Justice's treasure trove of cash deposits that, as evidence has shown, could put a king's fortune to shame? Your Honor, Mr. President, siya na po mismo ang umamin. The Chief Justice himself admits that he owns 3 peso accounts with an aggregate deposit of 80.7 million pesos and $4 accounts with a total of 2.4 million US dollars, none of which he declared in his SALN. He says that the family members commingled the funds in the same peso bank accounts along with the funds of the Basa Guidote Enterprises Inc. to earn higher interest. But oddly enough, the highest magistrate, who is presumed to be trained in the law and the rules of evidence, presents no documentary proof or any evidence whatsoever to support his claim other than his self-serving statements. There is a legal presumption whoever possesses the rights of ownership over a thing is presumed to be the owner thereof. His dollar deposits, he says, are the result of his foresight in dollar hedging since the late 1960s. Again, he shows nothing to prove this other than his testimony. The Chief Justice has woven a fantastic tale in his desperation to explain his incredible wealth. A legal presumption of unexplained wealth arises when a public official acquires an amount of property or cash during his incumbency that is manifestly out of proportion to his salary and to his other lawful income. In fact, Your Honor, the Chief Justice Renato Corona, as ponente in the case of Republic versus Sandigan Bayan and Ferdinand E. Marcos, wrote that when an official's assets are grossly disproportionate to their income, then the excess is prima facie ill-gotten. The burden is therefore placed on the official to prove that it is not. Saan man po nanggaling ang kanyang salapi, ilan man ang kanyang magagarang condo units o lupain, gaano man karaming bank accounts at gaano man kalaki ang laman nito, hindi na po yan ang pinag-uusapan natin ngayon. Ang tanong, nasa SALN ba niya ang mga ito? At the core of Article 2 is the question, did Respondent Corona declare his peso and dollar deposits in his SALN as required of him by the Constitution and the law? He did not. While the Chief Justice admits his non-declaration of all his cash assets in his SALN, he stubbornly insists that his failure to do so is justified. According to the Chief Justice, he did not declare his dollar deposits because he believed that it is covered by the absolute confidentiality of foreign currency accounts under the Foreign Currency Deposits Act. This interpretation of the law is very disturbing. We beg to disagree based on the law itself and the principles of public accountability. Your Honor, the prosecution submits that there is no conflict between the constitutional requirement of SALN and Republic Act 6426, or the law of secrecy of foreign currency deposits. The SALN requirement is addressed to government officials and employees to implement the constitutional provision on public accountability. It requires them to declare all their assets and net worth and makes no distinction between peso and foreign currency cash assets in the spirit of transparency and good governance. On the other hand, the law on secrecy of foreign currency deposits applies to banking institutions, and its prohibition is addressed to the banks, not to the depositors. It penalizes bank employees who disclose details about foreign currency deposits of their depositors, but allows the depositors themselves to waive the protection. To adopt the Chief Justice's interpretation of the law would be to encourage dishonesty in government and would lead to the absurd situation where the law itself protects ill-acquired wealth hidden in foreign currency accounts. This is how the Chief Justice, the highest magistrate of the land, who is expected to possess superior legal wisdom, interprets the law to protect his own interest. Your Honor, given all the things that we know now, after 4.5 months of trial, we go back to the question that we asked at the beginning of these proceedings. By what standards should Chief Justice Renato Corona be judged? We had answered, by the highest standards. Standards that are fair to demand of a Chief Justice and any member of the judiciary for that matter. Article 8, Section 7, Paragraph 3 of the Constitution provides. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. A nation of heroes and honorable people demands that the Chief Justice Corona be judged by the conduct and character displayed by Abad Santos and Amoran. Against such standards, we then ask, does Respondent Corona's failure to completely, truthfully, and faithfully declare his assets, liabilities, and net worth constitute an impeachable offense? Our answer is yes, because it is both betrayal of public trust and a culpable violation of the Constitution. It is lying. It is dishonesty. It is deception of the highest order. As explained by Constitutional Commissioner Rustico de los Reyes, betrayal of public trust is a catch-all phrase, which includes all acts which are not punishable by statutes as penal offenses, but nonetheless render the officer unfit to continue in office. It includes betrayal of public interest, inexcusable negligence of duty, tyrannical abuse of power, breach of official duty by malfeasance or misfeasance, cronyism, favoritism, etc., to the prejudice of public interests and which tend to bring the office into disrepute. As shown by the evidence, Chief Justice Corona's violation is culpable, for it is willful and intentional, judging by the habituality and sheer magnitude of the falsities, inaccuracies, and omissions in his SALNs. His lies in his SALN run into hundreds of millions and cannot be ignored. All this belie defense of good faith. In the case of Ombudsman versus Racho, the Supreme Court said, dishonesty begins when an individual intentionally makes a false statement in any material fact. It is understood to imply the disposition to lie, cheat, deceive, or defraud, unworthiness, lack of integrity, lack of honesty, probity or integrity in principle, lack of fairness and straightforwardness, disposition to defraud, deceive, or betray. Indeed, an honest public servant will have no difficulty in gathering, collating, and presenting evidence that will prove his credibility. But a dishonest one will only provide shallow excuses in his explanation. Ginoong Pangulo, sa paghahain po namin ng aming ebidensya sa tribunal na ito, sana po matandaan natin nang si Delsa Flores, isang simpleng empleyado ng hudikatura, ay hindi nagdeklara ng maliit na sari-sari store sa kanyang SALN. Tinanggalan po siya ng trabaho. Ang sabi ng Korte Suprema, although every office in government service is of public trust, no position exacts greater demand for moral righteousness and uprightness from an individual than the judiciary. Ladies and gentlemen of the Senate, we come now to the very heart of these impeachment proceedings. Is Chief Justice Renato Corona morally fit to remain as Chief Justice of the Supreme Court? The damning revelations that came out of this impeachment trial go into the very core of the man's character. Tulad po ng sinabi namin sa umpisa, pagkatao po ang ating pinag-uusapan dito. Can we trust a man who has repeatedly thwarted the people's will by lying under oath in his SALN to conceal wealth that he could not explain? Can we trust a magistrate who was very much willing to receive discounts, favors, and other benefits from parties with pending cases before the Supreme Court? And can we trust a man who took advantage of his position and abused his power to commit grave injustice and oppress his relatives in the name of greed? Mr. Senate President Juan Ponce Enrile, ladies and gentlemen of the Senate, the House of Representatives, in impeaching the Chief Justice, took the first step towards the fulfillment of our oath as the keepers of our people's trust. We have done our part as prosecutors in this impeachment trial, despite the odds. No matter what the outcome will be, we know in our hearts that we have contributed to the betterment of our nation. This impeachment is not so much about Renato Coronado Corona, but it is more about setting aright that which is wrong. It is now up to the honorable members of the Senate, the senator judges, to take the final step to restore the greatness that we have lost. The people are hopeful. Let us end this right. Let us decide in favor of truth and greatness. Let us be done with Chief Justice Renato Corona. Thank you very much and good afternoon.
Majority Floor Leader.
Mr. President, I move that we recognize the counsel for Chief Justice Renato Corona to present the arguments for the defense.
It is the defense turn, so who will speak?
Your Honor, please may we ask permission for Dean de Los Angeles as the speaker for the defense, Your Honor.
Granted. Proceed.
Your Honors, my countrymen, after 42 hearings, there are two matters I wish to discuss. First, whether the confidentiality of foreign currency deposits under Republic Act 6426 is a justification not to disclose dollar accounts in the SALN. Second, if it is not a justification, whether its non-disclosure in the SALN amounts to an impeachable offense. Your Honors, the confidentiality under Republic Act 6426 justifies a public official from disclosing his dollar accounts in his SALN. RA 6426 provides that all foreign currency deposits, without any qualification as to whether they are owned by a private or a public person, are absolutely confidential, except upon the written waiver of the depositor. Even if Section 8 Republic Act 6713 requires public officials to file a SALN under oath, this provision does not amend the confidentiality of dollar deposits under the Foreign Currency Deposit Act, which is a specific law. Besides, our Constitution provides, under the Bill of Rights, a right to privacy and a right to information. I posit that the right of access to the SALN of public officers is covered by the right to information. However, in Republic versus Eugenio, the Supreme Court ruled that bank accounts are not covered by the constitutional provisions regarding the right to information and full disclosure. And I quote, "Unless the Bank Secrecy Act is repealed or amended, the legal order is obliged to conserve the absolutely confidential nature of Philippine bank deposits. Any exception to the rule of absolute confidentiality must be specifically legislated." When the Supreme Court issued the temporary restraining order in favor of PS Bank, Justice Arturo Brion, in his concurring opinion, not only cited the Eugenio case, but added, and I quote, "Notably, the court declared that bank accounts or the bank accounts law are not covered by the right to information under Article 3, Section 7, and the requirement of full public disclosure under Article 2, Section 28 of the Constitution, which is statutorily implemented through Republic Act 6713. According to Justice Brion, Republic Act 6713 did not repeal Republic Act 6426, and I quote, "The implied repeal of inconsistent laws that Republic Act 6713 mandates cannot be interpreted as a repeal of the express substantive right granted to confidentiality under Section 8 of Republic Act number 6426, even if the latter was enacted earlier. Implied repeals are not favored. The presumption is against inconsistency or repugnance, and accordingly against implied repeals. In BSB Group versus Go, the Supreme Court also ruled that in case of doubt, the confidentiality of bank deposits should be favored. The court said, and I quote, "Should there be doubts in upholding the absolutely confidential nature of bank deposits against affirming the authority to inquire into such accounts, then such doubts must be resolved in favor of the former. This attitude persists unless Congress lifts its fingers to reverse the general state policy respecting the absolutely confidential nature of bank deposits. We cannot therefore hold the Chief Justice liable because he believes in all good faith in the absolute confidentiality of foreign currency deposits. It is argued by some, however, that insistence on the rule of absolute confidentiality will provide a safe haven for grafters and corrupt public officials who will simply conceal their ill-gotten wealth as dollars, never to be reported or declared. They say that the Chief Justice is wrong to adopt the view favoring absolute confidentiality of foreign deposits, and that therefore he must be convicted. While there may exist a danger that corrupt officials may escape discovery, let us not mistake the Chief Justice's use of this interpretation for the possibility of its abuse. In this case, there is no showing that the non-inclusion of certain bank accounts was tainted with any malice or fault. What we have here is a situation where the Chief Justice, consistent with his practice for the last 2 decades, assumed that his reliance on the letter of the law could not be wrong. Yes, there may be what we call a lacuna in the law, a gap or a hole which may pertain to an unsettled question of law. In this case, the gap may have to do with the confidentiality of dollar deposits vis-a-vis the duty of public officers to disclose their assets and net worth in the SALN. Notably, even BIR Director Estrella Martinez, in all her 32 years of SALN examination, did not find any public officer who disclosed a dollar deposit. Plainly, all these public officials understood RA 6426 and 6713 in the same manner as the Chief Justice. We are all aware that the separation of powers requires us to look only to the Supreme Court decisions as definitive interpretations of the law. To this day, however, there is no ruling that squarely applies to the confidentiality provided under RA 6426 with respect to the SALN. The alternative to filing this lacuna or to filling this lacuna is through an express repeal by amendatory legislation. In both cases, the results of these processes are decidedly prospective. In other words, the Chief Justice cannot be made answerable for his interpretation of the law prior to a Supreme Court ruling or legislative amendment, explicitly declaring his interpretation as erroneous. To repeat, there is no liability for an erroneous interpretation of the law when made in good faith. The Chief Justice, Your Honors, has acted consistently, unwavering in his conviction and belief that RA 6426 affords him full and absolute confidentiality. As held in Francisco versus Nagmamalasakit na mananananggol, just because he is the Chief Justice does not imply that he gets to have less in law than anybody else. The law is solicitous of any individual's rights, irrespective of his status in life. Even if we assume that the Chief Justice should have disclosed his foreign currency deposits in his SALN, it is submitted that this non-disclosure in the SALN will not amount to an impeachable offense. Section 2, Article 11 of the Constitution provides that the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. This enumeration indicates that the impeachment and conviction of these high government officials should be based on nothing less than high crimes. Treason is abominable because it is an act of disloyalty to our country. It carries a penalty of 12 years and 1 day to death. Bribery is penalized by 6 years and 1 day to 12 years. Graft and corruption also carries a penalty of not more than 10 years. Betrayal of public trust, which is unique to the Philippines, must also be based on a serious crime with a high penalty. For certainly, the high government official should not be impeached and removed from office for a minor breach of the law. In this case, Chief Justice Corona is not charged with treason, bribery, graft and corruption, or even ill-gotten wealth. Article 2 of the Articles of Impeachment accuses the Chief Justice of not disclosing his SAL-N to the public. The Chief Justice is, however, exempted from any liability for the disclosure of his SAL-N. He is bound by the resolutions of the Supreme Court and Bank regulating the release to the public. It is also said that the Chief Justice did not disclose all his assets in his SAL-N. We have painstakingly shown, however, that the real properties allegedly belonging to the Chief Justice are not actually his, and therefore need not be disclosed in his SAL-N. The remaining issue is whether the non-disclosure of his other peso and dollar deposits amounts to a culpable violation of the Constitution and or a betrayal of the public trust. The defense has shown that the peso holdings or deposits of the Chief Justice were disclosed in his SAL-N. The other peso accounts do not belong to him, but are either owned by his children or held in trust for Basa Guidotti Enterprises or as part of the common fund from his mother. The Chief Justice relies on the basic principle that what he does not own, he should not declare as his asset. It is therefore submitted that he cannot be held liable for culpable violation of the Constitution. His dollar accounts were not included for reasons earlier stated. According to Committee Report number 1214, in the impeachment of President Elpidio Quirino, a violation of the Constitution committed unintentionally or involuntarily or in good faith or through honest mistake of judgment is not a ground for impeachment. Similarly, the Chief Justice cannot be held liable for betrayal of public trust. Father Joaquin Bernas explained that betrayal of public trust implies deliberate intent and perhaps a certain degree of perversity, for it is not easy to imagine that individuals of the category of these impeachable officials would go so far as to defy knowingly what the Constitution commands. It must be of the same gravity as the other offenses in the class. In other words, not every violation of public trust is an impeachable offense. It is therefore respectfully submitted that the failure to disclose in the SAL-N his dollar accounts will not amount to an impeachable breach of trust. Indeed, the penalty of violation of the SAL-N is only a fine not exceeding 5,000 pesos or imprisonment not exceeding 5 years, or both, which cannot compare with the severe penalties for treason, bribery, and graft and corruption. More importantly, even before we can get to the matter of penalty for non-disclosure or non-inclusion, RA 6713 itself provides a corrective measure under Section 10 thereof. Per force of logic, there is no violation of law where the law itself provides a corrective measure. All that needs to be done is to call the attention of the public officer. This is the remedy of first resort, not to punish him, much less to remove him from office. I further wish to point out that pursuant to the separation of powers, our Constitution vests the important role of impeachment in Congress, hoping that it will act independently in hearing the impeachment of the officials of the other branches. Regrettably, we have witnessed the unusual rubber stamping by the majority of the House of Representatives, who never even read the articles of impeachment. The blitzkrieg endorsement of the articles of impeachment to the Senate was principally undertaken by the party mates of the President. The President then repeatedly declared that he wanted the Chief Justice removed. In support, the executive branch then lent its full and awesome powers to interfere in the impeachment proceedings, to oust the Chief Justice, and to intimidate the Supreme Court. For example, the Secretary of Justice threatened other Supreme Court justices with impeachment. The Land Registration Authority then falsely listed 45 alleged properties of the Chief Justice. The Bureau of Internal Revenue divulged confidential income tax returns and commenced investigation of the Chief Justice and his entire family. The AMLAC looked into the bank accounts of the Chief Justice without a predicate crime or court order. The Ombudsman exaggerated and testified that the Chief Justice has 82 bank accounts and $10 to $12 million in deposits. The Commission on Audit disauthorized the purchase of the Basagidotti property after 11 long years. Decadence of their actions imply a conductor. Such undue interference by the Executive Department in order to undermine the Judicial Department is clearly intended to weaken and then control the latter department, to do away with effective checks and balances under a tripartite government system. Under the pretext that the Chief Justice and the Supreme Court are impediments to reforms sought by him, the President aims to remove the Chief Justice and make the Supreme Court subservient to his whims. It is our fervent hope that the Senate will not lend its assistance to this plot. Let not this institution allow the guillotine to fall on the judicial independence. During the time of U.S. President Franklin Delano Roosevelt, a similar situation occurred. After being repeatedly rebuked by the Supreme Court, a peeved President Roosevelt wanted to undermine and control the judiciary by seeking to create additional positions in the U.S. Supreme Court so that he could appoint a majority of the members. In refusing to pass the amendment, the U.S. Senate Judiciary Committee wrote in its report, and I quote, "Let us, of the 75th Congress, in words that will never be disregarded by any succeeding Congress, declare that we would rather have an independent court, a fearless court, a court that will dare to announce its honest opinions in what it believes to be the defense of the liberties of the people, and a court that out of fear or sense of obligation to the appointing power or factional passion approve any measure we may enact. We are not the judges of the judges." Finally, the case of the Chief Justice is not complete without reference to the fundamental right to the presumption of innocence. We have seen the absolute lack of any damning evidence presented against the Chief Justice, even where it was alleged by the prosecution that his acts are punishable violations. The defense has shown that the Chief Justice relied on sound legal basis for his position, and in all instances guided by good faith and without malice. But beyond what the prosecution failed to prove, what strengthens the presumption of innocence is the credibility of the Chief Justice in giving justice, in proving himself forthright, courageous, and true. His innocence is buttressed by the common sense truth behind his testimony, affirming the experience of many Filipinos in their own families. His courage is shown by his dauntless determination to fight this impeachment and the horrid cesspool of propaganda along with it. Most of all, he has responded to the call of the Filipino people by defying all expectations and raising the bar for all public officials. Despite his reliance on the confidentiality of RA 6426, the Chief Justice has, upon the request of the Senate, waived the confidentiality of his bank accounts, thereby setting the standard of transparency in public service. Indeed, the innocence of the Chief Justice arises not only from the abject lack of evidence against him, but from his conduct, wholly consistent with a clear conscience. Truly, Your Honors, you are called upon to judge a man who has proven why he is the Chief Justice. After I speak, the prosecution will lace your ears with the last lines or even the last paragraphs, but their courtship shall be in vain. For borrowing the words of the counsel of President Clinton, theirs will not be the last voice, because the voice I will leave with you is the voice of reason, the voice of the law, and the voice of truth, the voice that will ring forever in your conscience. Your Honors, the other defense counsels and I respectfully request that you render a verdict of acquittal.
Majority Floor Leader.
The prosecution may continue. They have 40 minutes left.
Mr. President, before the second speaker for the prosecution speaks, may we request for 1 minute recess just to allow us to set up the PowerPoint presentation.
1 minute recess.
We have a 1 minute recess to prepare for yet another PowerPoint presentation in the impeachment trial. Earlier, we heard the first parts of the closing arguments from lead prosecutor Congressman Neil Tupas Jr. and defense counsel Eduardo de Los Angeles. First, let's go to the presentation, the arguments of Congressman Tupas. His main argument is that Chief Justice Renato Corona is not morally fit to stay in office. He said that we must do away with Chief Justice Corona. He said that by his own admission, the Chief Justice did not declare all his cash assets in his SALN. He also rebutted the argument of the Chief Justice, citing the absolute confidentiality of his dollar accounts. He said this legal interpretation is very disturbing because it paves the way for other public officials to invoke the same confidentiality and hide any of their ill-gotten wealth. We also heard Tupas say that Corona should be convicted because, yes, he committed an impeachable offense, according to him. He violated the Constitution and betrayed the public trust. He said that this is an impeachable offense. His omissions and his SALN is impeachable because it was intentional. He said it was not done in good faith. There was clear intention shown in the magnitude of the inaccuracies where the amounts totaled to hundreds of millions of pesos. He also said that the House of Representatives, the prosecutors, have done their job in protecting the public's trust, and he said it is now up to the senator judges to also do their part by convicting the Chief Justice. Now we go to the argument of the defense of Dean de Los Angeles. He said that no, the Chief Justice did not commit any impeachable offense because his legal argument is sound. It is based on the Foreign Currency Deposit Act. He said if there is anything wrong with the law or if the law is erroneous, it must be corrected through legislation. He said that Corona should not be faulted for his legal interpretation. He also responded to the argument of Senator Franklin Drilon that the law must not be used as a safe haven for the corrupt. He said that meaning de Los Angeles, Corona must not be liable for his interpretation that may lead to the possibility of abuse. Dean de Los Angeles basically laid out various Supreme Court rulings where he said that if there is any ambiguity in the law, the court must decide in favor of the confidentiality of bank accounts. He said that even if the public has a right to information, that does not go over or that does not supersede a person's right to keep his bank accounts confidential.
Mr. Majority Floor Leader. Andyan? Session resumed. Majority Floor Leader.
Thank you. Yes, Mr. President. May we know from the prosecution if they are ready for their second speaker?
Are we recording the time?
Mr. President, may we request that Congressman Rudy Fariñas of the 1st District of Ilocos Norte be recognized as the second speaker for the prosecution.
Granted.
Thank you.
Proceed.
Good afternoon, Mr. President, and the honorable members of the Senate sitting in impeachment.
Narinig po natin yung depensa, mga alegasyon nila, at mismong ang mga pahayag ni Chief Justice nung siya po ay nagsalita dito nung Martes at saka Biyernes. Medyo anticlimactic nga po ng konti dahil yung summation, narinig naman po natin mula sa bibig ni Chief Justice Renato Corona mismo. Yung depensa po ni Chief Justice Corona, I can put it in one word. Pwede ko pong sabihin po sa isang salita, palusot. Ang alegasyon po ni Chief Justice ay ang kasong ito laban sa kanya ay dala ng matinding galit at paghihiganti sa kanya. Tama po siya na kami ay may matinding galit. Subalit maling-mali po siya kung ano yung ikinakagalit namin. Hindi po kami galit sa pagkatao ni Chief Justice. Galit lamang po kami sa ginagawa niyang katiwalian bilang pinuno ng hudikatura na dapat sana ay siya maging huwaran para sa atin lahat na nasa gobyerno. Hindi po kami nag-aksaya ng panahon at mahabang oras sa loob ng halos 5 buwan. Pag-aralan lahat ang mga ebidensya namin, ihanda ang aming mga testigo, batikusin at minsan-minsan na pagsasabihan dito na para kami mga bata. Nagsasakripisyo po kami sa aming mga pamilya para lamang maging kasangkapan di umano ng paghihiganti ng Pangulo ng Pilipinas sa personal na isyu ng Hacienda Luisita. Tiniis po namin lahat ito, gaya rin po ng malaking pagtitiis ng mga kagalang-galang na senador. Dahil po sa pagpapatupad po namin sa aming sumpa na kami po ay tatalima at itataguyod namin ang saligang batas. Naglakas loob po kami na panagutin at nais patalsikin ang pinakapangyarihan na tao sa hudikatura dahil ito lamang ang tanging paraan para mabawi ng taong bayan ang opisinang ipinagkatiwala sa kanya. Ang pangalawang palusot po ni Chief Justice ay yung sinabi po niya na noong 2 piso pa lamang ang palitan ng dolyar noong late 60s, siya at ang kanyang may bahay ay namili na ng mga dolyar dahil matibay po ito kaysa piso natin. Noong narinig po ni Pangulong Enrile ang sinabi ni CJ Corona, hindi niya napigilan ang sarili niya para kumpirmahin kay CJ Corona kung anong taon yon. Sagot ni CJ Corona, ito po, ang transcript. Chief Justice, ang exchange rate po noong mag-umpisa kaming mag-ipon nitong mga foreign exchange na ito noong late 60s ay nasa 2-1 pa lamang. The presiding officer, how much? CJ, 2-1 po. Noong mag-umpisa po kaming mag-ipon ng mga dollars namin, 2-1 po pa lang ang exchange rate. The presiding officer, when was that, Mr. Chief Justice? Chief Justice, mga late 60s po. Dahil ako po ay nagsimulang magtrabaho 1968. Ngayon po ay halos 45-1 na ang exchange rate kung natatandaan po ninyo. The presiding officer, are you sure that late 60s or early 60s? Sagot po ni Chief Justice, late 60s. The presiding officer, that is after 1965? Opo. Alam po ni Presidente Enrile kung ano ang palitan ng dolyar noong mga panahon na yon dahil siya po ay Undersecretary of Finance noong 1966 hanggang 1968. Naging Customs Commissioner po siya at Insurance Commissioner. At pagkatapos po ay naging Secretary of Justice. Totoo ba yung paliwanag ni Chief Justice? Chief Justice Corona graduated from the Ateneo de Manila University in 1970 and at its law school in 1974. I know because he was 1 year ahead of me both in the College of Arts and Sciences as well as in the College of Law. Thus, he graduated in high school in 1966 and in elementary in 1962. Noong 1962 po, ang palitan po ng dolyar sa piso ay 3 pesos, yan po. Yung isang dollar, 3 pesos and 68 centavos po. The exchange rate, if we are to believe Chief Justice Corona that he started saving US dollars when the rate was 2-1, such could have only been between the years 1948 to 1959.
He wants us to believe that when he was in grade 4 in 1959, he was such a visionary that he already started buying dollars. The exchange rate in 1969 when Renato Corona was in fourth-year college was 3 pesos and 90 centavos to the US dollar. Maliwanag po na palusot at pagsisinungaling sa Senado at sa buong mundo. Pangatlong palusot. Last Friday, when C.J. Corona was asked by Senator Cayetano how much money he had in the bank, he admitted of having, at the very least, 2,400,000 pesos, dollars, and 80 million pesos. Chief Justice Corona once asked to believe that he did not declare this in his SALN because of Republic Act 6426 as advanced by my esteemed colleague. But Republic Act 6426 took effect in April 4, 1972, or almost 15 years before the 1987 Constitution mandated such filing of SALNs. It was only in the dito lamang po sa 1987 Constitution. Wala po sa 1935, wala po sa 1973 Constitution yung kautusan ng saligang batas na tayo po ay magdeklara ng ating assets and liabilities. Kaya nga po, pursuant to Section 17, Article of the Constitution, Republic Act 6713, otherwise known as the Code of Conduct and Ethical Standards for Public Officials and Employees, was enacted into law in February 20, 1989. It provides for the following. Ito po ang sinasabi ng batas. Statements and disclosure. The two documents shall contain information on the following. Letter C. Nakalagay po dito. Kung ano dapat ilahad po natin doon. All other assets such as investments, cash on hand, or in banks, stocks, bonds, and the like. Very clear po. Dito sa batas na nagpapatupad sa Constitution na sa ating deklarasyon po, maski pera po sa baol o sa bangko, kailangan ideklara po natin. Nasabi po nung kabila na yung kanilang witness o yung kanilang authority na hindi naman po hinarap sa atin dito, wala pa siyang nakitang SALN na may nakadeklara na dollar. Hindi naman po kasi kailangan sabihin mo dollar, pwede mo na i-convert Halimbawa po, kung ang cash on-hand mo is may $100,000 ka, hindi pwede mo pong ilagay na 4.5 million kung yun ang palitan. You don't have to say it is in dollars. Kaya lang po, si Chief Justice, nagpapalusot po sa 6426 na sinabi ko na nga po, 15 years pa po na pasa yung batas na yun. Napakaliwanag po ng ating batas. Tignan po ninyo sa ating SALN form. Ito ang pinirmahan po ni Chief Justice sa kanyang SALN form. Kung pwedeng ipakita po dyan. I hereby certify to the best of my knowledge and information that these are the true statements of my assets, liabilities, net worth, business interest, and financial connections, including those of my spouse and unmarried children below 18 years of age, as required by and in accordance with Republic Act 6713. Ayun po. Nakapirma po siya at nakalagay po doon sa unang paragraph, required by and in accordance with Republic Act 6713. At ang requirement nga ng 6713, maski na anong pera mo, maski nakatako, i-declare mo dahil hindi. Kaya po, maski naman po yung peso, may secrecy rin po naman yan. There is also secrecy in peso deposits, but you also have to declare. Because ang pinagbabawal po ng 6426 is anyone looking into the account of a depositor. Hindi po pwedeng ibigay ng bangko yun. Pero yung nagme-may-ari po ng deposito, kailangan ideklara po niya kung magkano pera niya sa bangko. Dahil kung hindi po, napakasamang interpretasyon po nito. Lahat po ng gustong magtago ng pera, bibili po ng dollar o foreign currency units para hindi na po i-declare sa SALN, kawawa po naman ang ating bansa. So, very clear po. Si Chief Justice po, pwede siyang, dalawang batas po ito 6426 at saka 6713. Yung 6713, sabi niya, dapat ideklara mo kung ano yung pera mo. Nasa kamay mo man o nasa bangko. Yung isa naman, bawal sa bangko maglahad kung ano yung deposito. he has the option to obey the law. What does he wish to obey? Eh di, i-declare po niya yung pera niya. Eh, ano naman ang violation sa 6426 kung i-declare niya kung ano ang pera niya sa bangko? Wala pong violation. In fact, pwede nga niyang iladlat. At katulad nga ng ginawa niya dito, ipinagmamalaki po niya na sila na raw po ang unang nag-waive ng kanilang deposits. So, very clear po na yung mga sinasabi ni Chief Justice about 6426 ay palusot. Hindsight lang po yan dahil nahuli po. Nahuli po. Katulad din po yung mga $2.4 million niya na binili niya noong 2:1 po lamang yun. Maski ano pong kwenta ang gawin natin, hindi po aabot yun. At kung totoo naman po yung sinabi niya, na noon pa, bago siya pumasok sa gobyerno, nakaipon na siya ng ganong kalaking pera, eh di, ibig sabihin doon, all these years, nandun po yung pera niya. Pero kung tignan po yung salin niya, nung unang pumasok sa gobyerno, eh meron pa siyang Carlon na 300,000 pesos. May utang pa siya na 300,000 po para sa kotse. Eh milyon-milyon pala yung pera niya. Ba't pa siya mangungutang lang 300,000 para sa kotse niya? At nung sumunod na mga taon po, makikita sa salin, may utang din po siyang 1 million sa mga bangko. Eh milyon-milyon pala yung kaban niya. Bakit ka mangungutang kung ang dami mong pera? Ganon na rin po yung bumale siya sa Basagidote ng 11 milyon. Ba't ka ba bale doon sa Basagidote? Eh, kanya rin pala yun. Nasa kanya rin pala yung pera. At yun ay tatakalakayin ko po sa susunod. Pang-apat na palusot ni Chief Justice. Sa testimonya ni Ginoong Corona, inamin din niyang meron siyang 80 milyong piso na hindi niya idineklara ang mga ito sa kanyang salin. Ang palusot ni Justice Corona, hindi siya obligadong ideklara ito dahil commingled o halo-halong pondo at hindi lang siya ang nagmay-may-ari ng milyones na ito. Kung totoo ito, bakit sa kanya lamang nakapangalan ang deposito? Alam naman po natin, pwede naman joint account at saka lahat-lahat para kung ilan po. At saka medyo nakakalito po na siya, namimili ng dollar, mula pa nung 2:1, tapos yung anak niya na nasa Amerika na kumikita ng dollar, eh pinapalit naman niya ng peso. At si Serena daw, eh may 15 million o may 10 million. Hindi ko po maintindihan. At meron po siyang 80 million pesos, eh ba't di palit sa dollar yun para mas okay? Pero hindi ho, nahuli lang po na yun ang hawak niya. Kaya yung mga palusot po, minsan mahirap, hindi po magtugma-tugma. We tend to contradict ourselves if we do not tell the truth. In the case of Fultron versus Ironworks and China Banking, a depositor is presumed to be the owner of the funds standing in this name in a bank deposit. Natural po, siya nakapangalan doon. At kung ako naman po kaya, yung mga anak ko po, sa edad ko pong ito, ibinibigay ko pa nga yung pera ko sa pondo nila para kung may mangyari po sa akin, eh di kanila na yung pera. Ito baliktad po dahil na double heart bypass na. Eh kung malasim po siya, eh di pa paano pa makukuha yung pera na 80 million dahil nakapangalan po sa kanya yan. Eh, babayad ng estate tax, katakot-takot na transaction po yan dahil hindi na malalabas sa bangko yan. Kasi hindi naman po totoong kuminggal dito eh. Palusot lamang po yun dahil para nga po hindi naman po idedeklara yan. At saka kung totoo po yun, nagtataka po naman kami ang haba-haba po ng panahon mula pa noong March 22, kanila na po yung turn na magbigay ng mga witness kung sino-sino po pinipresenta dito hanggang medyo nauubusan na ng pasensya po yung mga kagalang-galang na senador. Kailan pa namin makikita yung kliyente ninyo? Dahil noong pasano, edi linabas na ni Ginoong Corona dito yung alleged Far East Bank account executive niya para sabihin, ay totoo po na nung ganito, talagang ganyan kalaki na ang pera ni... At saka control po niya lahat itong funds, ang records nito. Di dapat nilabas po niya. Pinakita niya, ay ito, maski dong grade 6 ako, nag-iipon na ako, meron akong passbook dito, meron akong certificate of deposit, o yung bank manager lamang po. Pero wala po eh. Maski po yung mga anak niya na may kontribusyon doon sa punto, nandun po nanonood sila noong nag-testify siya. Hindi po ba pinasusubpina po namin yan, pero hindi pinayagan dahil asawa, mga anak, eh di dapat sila po nagtestigo dito. Pero siya po nagtetestigo para dun sa mga anak niya who we cannot cross-examine. Hindi naman po yata tama yon. Kaya medyo palusot din po yata yon. Dahil kung makikita po natin sa ebidensya, ang laki-laki na nung pera nung Carla Corona Castillo. Sa kanya rin po binenta ni Chief Justice yung bahay at lupa nila for 19 million pesos. Binenta niya kay Carla. Eh sabi ni Chief Justice, kaming mag-asawa, hindi namimili ng real estate dahil pinag-aawayan niya ng mga anak. Pero binibenta niya yung property niya doon sa anak niya. Kaya, kasi po, palusot na lamang po yan. Kasi nga, noong 2000 po, sunod-sunod ang buying spree po si Chief Justice eh. Bumili ng condominium dito, bumili ng condominium dito, na hindi po idinedeklara sa kanyang salin. Napakita na po namin, yung mga Bellagio, columns and everything. Biglang-bigla, noong 2010 salin, doon lamang po lumabas. Dineclare niya. Bakit po? Nagbago presidente. Iba na ang presidente. So, biglang nag-declare ng mga property na binili 7 taon na nakaraan, yung isa 5 taon na nakaraan, yung isa 3 taon na nakaraan. Biglang-bigla, kailangan magbenta sa anak, kunyari, ng 11 milyon dahil ang dami ko na napamilya. Paano ko ma-explain ito? Pero hindi naman na kailangan explain. Aba, ang dami kong pera, oh. Meron akong $2.4 million yan. May 80 million pa nga kami. Pero ito po lahat ay maliwanag na palusot. Susunod po tayo. One last question. Sabi ko na, kung ganong kadami ang pera ni Chief Justice Corona, dapat naman po hindi na pinag-aawayan yung pera ng Basag Idota. Tignan po niyo yung salin niya. Taon-taon, binabayaran niya ng 1 million kuno. 11 million, tapos bababa ng 10, bababa ng 9, bababa ng 8, 7, 6, 5, hanggang, kunyari, nabayaran na po. Isang kaban lang naman po yun. Nung tinanong po ng isang senador dito, paano ka bumapayad doon? Binibigay ko kay Mrs. Cheque o kaso, cheque, bahala siya. Pero ide-deposit dito doon sa account niya. Hindi po ba? Bakit ka pa babayad kung sa'yo rin pala yung pera? Di ba kalukuhan na po yun? Ibibigay mo yung pera sa misis mo para i-deposit din niya sa sarili mong account. Nakakahilo po. Pero yun po ang paliwanag ni Chief Justice. Your Honors, our nation does not deserve to have a Chief Justice who intentionally and consistently hides the great bulk of his cash assets, reporting in his salary only a measly 1.97%, wala pong 2% po, of his total admitted cash assets. In short, Renato Corona, throughout his tenure in the Supreme Court, concealed from the public 98% of his total admitted cash assets, amounting to 180 million pesos. Tayo po. Tatalakayin ko po ng konti yung mga nasabi nung professor ko na si Dean Angeles. Ito po ang sinabi ng Supreme Court doon sa Francisco case. At sino po ang sumulat nito? Ito po ang concurring opinion ni Justice Renato Corona. Sabi po niya, impeachment under the Philippine Constitution as a remedy for serious political offenses against the people runs parallel to that of the U.S. Constitution, whose framers regarded it as a political weapon against executive tyranny. It was meant, open quotation marks, to fend against incapacity, negligence, or perfidy of the chief magistrate, close quotation marks. Even if an impeachable official enjoys immunity, he can be removed in extreme cases to protect the public. Justice Corona po nagsasabi ito. Because of its peculiar structure and purpose, impeachment proceedings are neither civil nor criminal. James Wilson described impeachment as confined to political characters, to political crimes and misdemeanors, and to political punishment. Close quotation marks. According to Justice Joseph Story, ito pa rin po yung ponente ni Justice Corona, quoting all these American authorities. In his commentaries on the Constitution in 1833, impeachment applied to offenses of a political character. Not but that crimes of strictly legal character fall within the scope of the power, but that it has a more enlarged operation and reaches what are aptly termed political offenses, growing out of personal misconduct or gross neglect or usurpation or habitual disregard of the public interest, various in character and so much indefinable in their actual involutions that it is almost impossible to provide systematically for them by positive law. They must be examined upon very broad and comprehensive principles of public policy and duty. Ito po ang definition ni Justice Corona tungkol po sa impeachable offense. Ayun po, Your Honors, wag po ninyong palusutin na si Chief Justice Corona. Nasabi ko na po minsan dito na ito po ay ginunto ang pagkakataon po natin. Sinasabi ko po natin dahil ang impeachment po ay two-step process yan. Kailangan po magkatugma ang House at saka Senate, kung hindi, wala pong mangyayari. Maski gaano po kakurap o may ginagawang masama yung impeachable officer at gusto ng Senado tanggalin, kung hindi po namin isasampa yung kaso, wala pong kaso. Kasi po, nasa House of Representatives, ang tanging kapangyarihan na magsampa ng impeachment. Ginawa na po namin ang trabaho namin. Isinampa namin po dito yung complaint at sa tingin po naman namin, napatunayan po namin ang kasalanan ni Ginoong Corona. Kung yung ordinaryong kawani ng Korte ay tinanggal ng Korte Suprema na pinamumunuan ni Chief Justice Corona dahil sa hindi na pagdeklara sa kanyang salin na mayroon siyang maliit na pwesto sa palengke. Opo, inalis po yung interpreter dahil hindi na nalagay sa salin na may stall siya sa palengke. At dito po sa atin sa Senado ay palalampasin natin o palulusutin natin na si Renato Corona, good faith naman na hindi niya idineklara yung kanyang $2.4 million at $80 million masisira, 80 million pesos, masisira po ang bayan natin. Ang dali naman pong palusot yan. Kung maulihan po ako ng 50 million, sasabihin ko, ambag-ambag kami ni na Senator Cayetano, Senator Marcos dito at lahat-lahat. Hindi naman po yata pwede. Nag-contribution kami sa pundo yan. Maski ako lang po ang nakapangalan. No? Sa nanay ko po yan. Ayun, nanay ko, pundo po niya yan. Hindi po pwede yun. Dahil ang presumption po, kung sobra-sobra, yung pera na sa sayo, yan ay galing sa hindi magandang paraan. Mga kagalang-galang na senador, huwag po tayong padadala sa mga palusot at maladramang payag ni Chief Justice Corona. Mas maliliwanag po kaysa sikat ng araw na inaabuso at binabaluktot po niya ang mga batas para itago po niya ang kanyang mga pera na kung saan nanggaling ay kaduda-duda. To keep a Chief Justice in office whose gross misconduct and dishonesty are a well-established fact will weaken the authority of the judiciary and undermine the rule of law. For lying under oath before the Senate and the Filipino people, Renato Corona should not only be given his wish to be excused as the Chief Justice of the Republic of the Philippines, he should be removed as the Chief Justice of the Republic of the Philippines. It would be the greatest disservice to our nation and people to allow him to stay any minute longer as the head of the judicial department of our government, the bulwark of truth and justice. The House of Representatives has done its constitutional duty of impeaching Renato Corona and proving his guilt, not only by clear and convincing evidence, but conclusive evidence brought about by his admission before the Honorable Senate of the charge against him under Article 2 of the Articles on Impeachment. Diyos tiyang ginaunay, Apo Presidente Juan Ponce Enrile, maraming salamat po mga kagalang-galang na senador sa inyong pagtanggap na mainit po sa amin dito sa loob ng halos 5 buwan. At sa sambayanang Pilipino, maraming salamat po.
Diyos tangina, nalaing kaunay.
Mr. President, we are ready to listen to the second part of the defense panel.
If Your Honor, please, 10 minutes of my time is being granted by me to a member of the defense panel. Your Honor, may we ask permission that he be given 10 minutes to to be deducted from my time, Your Honor. Thus making it I understand I have only 37 minutes pa? 40 pa? Oh. Charge against my time, Your Honor.
You have 35 minutes left. Unless there is any objection from the court, because the rule is 2 speakers.
No objection from the prosecution, Your Honor.
Thank you, Your Honor.
So what is the proposal now?
A second speaker be recognized to take 10 minutes of the portion of Justice Cuevas, Mr. President.
Granted.
Thank you, Your Honor.
Good afternoon to the senators and to the Filipino people. Malaki po ang paggalang ko kay Congressman Rudy Fariñas. Isa po siyang bar top notcher at galing din po siya sa parehong eskwelahan kung saan po ako graduate. Marami po siyang tinanong. Why did the Chief Justice declare 2:1? Why did the Chief Justice put the real properties under the names of his children? But the question is not why, the question is why not. Why not did they choose not to cross-examine him and pose these questions when he was here? The man presented himself before this court. He could have responded to all these questions, but they chose to waive. What is the effect of the waiver? Our rules are very clear that when cross-examination is waived, the testimony of the witness is unimpeached. It remains on record. The issue now here is his credibility. Let me bring this situation in its proper context. Every person is presumed to be innocent unless proven otherwise. That is very clear. I need not cite my basis for that because that is inherently natural in any system of government. The burden of proof in this case, it is also very clear. It is upon the prosecution. And if it fails to satisfactorily show the facts upon which they base their claim, the defendant is under no obligation to prove his defense. And if the prosecution fails to establish any of the elements necessary to constitute a crime, Chief Justice Corona is entitled to an acquittal. Let me go briefly to what they tried to prove. They tried to prove that the Chief Justice did not declare his assets in his SALN. They have presented witnesses, documents, but everything has been explained. It has been shown that the real properties which they wanted to prove were not really 45. It was only 5. And it was also shown that all 5 have been reported in the 2010 SALN. Are we going to trivialize this by saying that parking lots have to be included when in fact we know that the accessory follows the principal? We don't have to go to this anymore. Are we going to even go into the timing of when the chief should have reported this? Should it have been in 2008 or 2009 or 2010 when in fact witnesses here have testified under oath that the Chief Justice had issues about the unit? The Chief Justice was at the very least in good faith. That to me is very clear. Again, they have pounded the Chief Justice on his dollar accounts. They have said, inamin na niya. He already said that he has $2.4 million. What else is there to prove? As if the foreign currency deposit law does not exist. First of all, how are they able to prove this? This was proven through the testimony of the Ombudsman, which, with all due respect, in my opinion as a lawyer, is hearsay. The AMLA officer who prepared that report was never presented in court. That AMLA officer was never made to explain the entries that he made there. The AMLA officer was never presented to show the supporting documents that he relied upon. What did the ombudsman say? Hindi ko naintindihan yung AMLA report. So what did I do? I called the COA to explain to me the AMLA report. Of all the people to call the COA, why did not she call the AMLA? They were the ones who prepared the report. Bakit hindi sila ang pinagpaliwanag? And I propose an answer to these questions. The answer is very simple. The AMLA refused to testify because there was no court order allowing that inspection. That is very clear under the law. Authority to inquire into bank deposits, Section 11. The AMLC or the AMLAC may inquire into or examine any particular deposit or investment with any banking institution or non-bank financial institution upon order of a competent court. Did the ombudsman ask the AMLAC, where is your court order? She did not. She said she never investigated the AMLAC. When it has been established that there is probable cause that the deposits or investments are related to unlawful activities. What are these unlawful activities? Kidnapping, drug cases, hijacking. That is definitely not within the exception. Those are definitely not within the case. And so what did the Chief Justice do? Confronted with this situation, what did he do? He told everybody, I interpreted the law in accordance with the Foreign Currency Deposit Act. And he dared everybody. Hindi po ba pare-pareho ang interpretation natin yan? Isn't it? That's what he said. We all looked at it the same way. And he said, I will sign my waiver now, and I will prove to you that we all have the same interpretation. Let's open our accounts. Let's open our SALNs. Let's show it to the Filipino people that we have the same interpretation. Did anybody take up that challenge before the Honorable Court? Nobody. 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 Because the chief was able to show that his interpretation has been followed by most of the honest, hard-working public officials of our bureaucracy. There is no one witness here who testified that the Chief Justice accepted the bribe. There is none one witness here who said, ako po ang nagdeposito niyan kasi po may kapalit po na desisyon niyan. Not one. We are all surmising. They're saying, kaduda-duda yung movement ng pera. Napakalaki nung araw na to. Napakalaki nung ganun. Eh ba't hindi mo pinatunayan? Why did you not present the witness? We never decide cases based on doubt. We decide cases based on facts. That is how our system works. Now, yes, let me go to my last point. The prosecution says that the foreign currency deposit law is repugnant to the Constitution. My question is, can the Senate Impeachment Court declare the foreign currency deposit law unconstitutional? The Constitution is clear. Cases involving the constitutionality of any treaty, international executive agreement, or law shall be heard by the Supreme Court en banc. That is very clear. And isn't it the greatest height of contradiction if it is the Senate who will declare the product of its own work, the law that came from it, as contradictory to the Constitution? Galing po sa inyo yung batas. Umasa po ang mga kababayan. Tapos sasabihin nyo, hindi nyo pwedeng gamitin. pag kayo ay nalitis. And even assuming that there is a tinge of unconstitutionality, the rule is decisions of this nature have prospective application. And let me read. The principle of prospectivity has also been applied to judicial decisions, which, although in themselves not laws, are nevertheless evidence of what the laws mean. The reason why under Article 8 of the new Civil Code, judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system. A compelling rationalization of the prospectivity principle of judicial decisions is the imperative necessity to take account of the actual existence of the statute prior to its nullification as an operative fact negating acceptance of a principle of absolute retroactive invalidity. If it is unconstitutional, you cannot apply it retroactively. That is a medication that the chief has already took. You cannot tell the medicine, do not take effect. The person has already drank it. It has already taken its effect. If it is against the Constitution, it should only be applied prospectively. In closing, let me just respond to Congressman Tupas's statement that the Chief Justice peddled his position for material gains. That is a lie. That is an absolute lie. The Supreme Court is a collegial body. He might be referring to the FASAP case. He might be referring to the TRO granted to former President Arroyo. But the court acts as an entity separate and distinct from the individual personalities of its members. Consistently with the intrinsic nature of a collegiate court, the individual members act not as such individuals, but only as a duly constituted courts. Their distinct individualities are lost in the majesty of their office. In re almacen. Do not blame the Chief Justice, Congressman Tupas. It was the Supreme Court who rendered that decision. And if you're relying on the dissenting opinion of the Honorable Chief Justice Sereno, let me just say that the dissenting opinion cannot be sustained. A dissenting opinion is not binding, as it is a mere expression of the individual view of a court who disagrees with the conclusion of the majority of the members thereof. That will be all, Your Honor.
George Florida.
Good. Continuation of the defense, Mr. President.
May I just be allowed, Your Honor, to carry on the
You have
discussion?
27 minutes and 36 seconds.
Nabawasan yata naman kayo. Thank you. There seemed to be no question, Your Honor, as to the existence of Republic Act 6426, which deals with the confidentiality of foreign accounts deposit. But a question that apparently surfaced is the challenge or the allegation to the effect that this law is in violation of the Constitution. I do not know of any case whatsoever, nor any proceedings before the Supreme Court, Your Honor, questioning the legality and the constitutionality of that law. And simply because a senator or a justice say that the law is unconstitutional is no dictum to the effect that it is really unconstitutional, unless there is a pronouncement on the unconstitutionality of a law, it remains valid, it is effective, and it is enforceable against everybody within the Republic of the Philippines, Your Honor. As of date, I am not aware of any law or any case, Your Honor, that even merely challenges the constitutionality of Republic Act 6426, Your Honor. What does that imply? It is certainly valid, effective, and subsisting. And therefore, any and all depositors of foreign currency may avail thereof with no fear that they have lost the right to claim the confidentiality enshrined in the said law. Now, may we ask if there is any proceeding that the prosecution know whereby the constitutionality of this law is being challenged or had been challenged? Second, if there is any proceeding, has it resulted in the declaration of the unconstitutionality of the said law? We venture the guess, Your Honor, that the entire annals of political and constitutional jurisprudence may be searched in vain, but it will not yield any answer to the effect that this law have been declared unconstitutional. Now, may I go a little further, Your Honor? Even our legislative department, Your Honor, both of Congress, both the House of Representatives and the Senate, are unanimous in abiding with the dictum of confidentiality enshrined in this law. They have amended this particular law in sometime in 2002, Your Honor, and I am referring to Republic Act 91-94, which laid down the dictum, Your Honor, or the jurisprudence to the effect that whereas under Republic Act 6426, the only exception whereby that grants confidentiality to the Republic Act 6426, Your Honor, is the written lack or absence of written permission on the part of the depositor. Under the AMLAC law, which amended that particular provision, there are now two exceptions. First, it added a new exception, and that is when there is a criminal proceedings involving transactions which are illegal, violative of the AMLA law, and which had been filed before a court, Your Honor, and there are proceedings to that effect, and the transaction involved is any of the transaction mentioned on that law. For instance, anti-graft law, robbery, Your Honor, piracy, and a lot more of other enumerated. If the investigation deals with that particular mission, Your Honor, then it cannot, the depositor or cannot raise the defense that their deposits, Your Honor, are secured and therefore confidentiality is available to them under Republic Act 6426. Now, it had been argued, Your Honor, that does that not induce criminality, or does it not do a favor, especially to wrongdoers in the government service, whereby in order to avoid being criminally liable for their illegal acts, they convert their properties or money into foreign accounts deposit. That may be true, although I do not subscribe entirely to the correctness of such a view. Even if it exists, the remedy is not judicial, Your Honor. The remedy is legislation. Let us amend the law. Let us remove all these exceptions. The necessity for written permission must be removed if the entirety of what is alleged is that it is conducive to the commitment of illegalities, bribery, and violation of the anti-graft law on the part of public officials. But such is not the case. The legislature or Congress never envisioned a situation where, in the process of allowing foreign currency deposits, its depositors to claim confidentiality will be resulting in violation of the law on, for instance, smuggling, on kidnapping with ransom, and so on down the line. Now, secondly, it is very clear now, under the AMLA law as amended, that the confidentiality enshrined under the AMLA law under Republic Act 6426 may no longer be invoked if the prosecution, Your Honor, is a prosecution for any of the transactional offenses enumerated under the AMLA law. In other words, it is another exception whereby the depositor may no longer avail himself of what is known as foreign currency deposit, Your Honor. Now, I was amazed by the peroration of my learned colleague who had spoken before us, Your Honor, to the effect that allegedly there are a lot of falsities, a lot of lies permeating the declaration of the Honorable Chief Justice. I wanted immediately to agree with him, but his behavior before and during the presentation of the evidence or declaration by the Chief Justice does not approve of such kind of a plea, Your Honor. Why? Because Chief Justice Corona was here. He was available for cross-examination. If they doubted the credibility of Justice Corona, they should have taken advantage of the opportunity to cross-examine him. But it is on record, Your Honor, that there was no such cross-examination. In fact, it was categorically and positively waived by the lead counsel of the prosecution, Your Honor. And for that, we were heavily thankful because it shortened the stand activity of Chief Justice Corona, Your Honor. Now, they likewise referred to a lot of fabricated lies, Your Honor, more especially with respect to alleged buying of dollar deposits and so on. There is no statement on record, Your Honor, by the Chief Justice Corona that he started buying when he was still an undergraduate, continuously up to the point that he accumulated the amount that he admitted before this honorable court. I would like to commend Chief Justice Corona because notwithstanding several advices during the conferences that we had, that it is his right not to testify because no evidence, he cannot be compelled to testify, these proceedings being akin to a criminal case, he still insists on bringing before this court an admission to the effect that he has so much, that he has so much. He should be commended for that matter, Your Honor. But what is his explanation? Let me go a little further. What is the allegation with respect to the non-entry into the SAL of the Chief Justice Corona of the various properties alluded to by the prosecution, consisting of 45 pieces of properties? Little by little, Your Honor, while the trial goes on, we were able to show, I believe to the satisfaction of this honorable court, that there were no 45 pieces of properties and that ultimately there were only 5. That is why the other properties, which do not belong to him and which are registered in the name of persons whom he does not even know, need not be accounted for by him in the SAL that he filed for that matter. Now, he is also being charged or blamed or flawed because allegedly there were acquisitions made by him on a particular year, but they were not registered on that year, and they were registered later for a year or 2 years thereafter. We have no quarrel with that. Even our evidence shows that there is some vacillation on the part of the family of Chief Justice Corona because there were some doubts as to the validity of the transfer of the ownership to him. And therefore, his non-reporting may not be considered as intentional, fraudulent, malicious, and be the subject of an impeachment proceeding, Your Honor. Now, there were statements made here in connection with an employee, a law employee of the Department of Supreme Court of Justice relative to certain acts committed by him or her. But that cannot be equated. There is no parity of facts between that case and this case. That is merely an administrative case. This is an impeachment case, Your Honor, governed by the provisions of the Constitution and grounded on definite and specific grounds, Your Honor, namely culpable violation of the Constitution, treason, other high crimes, violation of the anti-graft law, and betrayal of public trust. may we ask the prosecution, Your Honor, whether there is any jurisprudence on the point that a mere deficiency or a mere inaccuracy in the entries made by a filer in the SAL is constitutive of a ground for impeachment which they claim now. I do not think, and I am not aware, I will be heavily thankful, Your Honor, and be fully appreciative if they can enlighten, because this happened to be my forte in criminal law, which is still my forte, being a member of the faculty of the University of the Philippines College of Law, Your Honor. Now, if it is not an impeachable offense, Your Honor, if it cannot be a ground for impeachment, then why are we building up matters after matters to the prejudice not only of the life, the honor, and the reputation of the Chief Justice, but his entire family, which even after years may no longer be erased or obliterated, because it's already sunk into the minds of the common people, being the subject of what we call conferences, even outside of this court, Your Honor. Now, let me go a little further, Your Honor, with the kind permission of this honorable court. There is a statement here made by the Honorable Ombudsman relative to the properties and deposits and cash deposits and accounts, Your Honor, which he declared while on the witness stand. Unfortunately, Your Honor, when we cross-examined her, she was truthful in admitting that there are no charges at the time filed against Chief Justice Corona. He is not a respondent nor an accused in any crimes mentioned under the AMLA law, but that pursuant to his general power as Ombudsman, she conducted the investigation on the strength of the affidavit complaint presented or submitted by several persons, Your Honor. These are the persons we introduced in evidence. We called them to testify in order to prove our contention that none of them had mentioned the existence of the $10 million account referred to in the report of the Honorable Ombudsman, Your Honor. Now, in order to justify further her statement on the matter with respect to properties and deposits, Your Honor, she waived certain papers, Your Honor. Allegedly, they were entries or they were papers, Your Honor, furnished her by the anti-laundering council, Your Honor. Now, at first, I was almost convinced that there is validity in her assertion, Your Honor. But when we examined the documents, Your Honor, and we were permitted by the court to do so, we found out that there was no proper attestation. There is only an initial, but we do not know whose initial they are. The question is that admissible in evidence? Our answer is no, because if it is not properly authenticated, then it is violative of Section 25, Rule 132 on evidence. And what does it say? May I be permitted to read the same? Whenever a copy of a document or record is attested for the purpose of evidence, the attestation must state in substance that the copy is a correct copy of the original or a specific part thereof, as the case may be. The attestation must be under official seal of the attesting officer, if there be any, or if he be clerk of court having a seal under the seal of said court. We notice, and we gather upon the examination of those documents, Your Honor, I hope I am pardoned by the court, that they are mere scrap of paper. The attestation required by law is not present, and therefore they are not admissible in evidence. If they are not admissible in evidence, what probative value that it says? I hope the court pardon me by saying it is totally useless, it is totally irrelevant to the matters brought about by her. Now, there were also statements made by the witness, by her, to the effect that these papers were allegedly furnished to her by the AMLA people, Your Honor. That allegedly was furnished here by the official of the AMLA, Your Honor. Some members or our colleagues in the legal profession say, why did you not call the AMLA people to contradict that they never have furnished her? That is not the job of the defense, Your Honor. The position here of the Chief Justice is akin to an accused in a criminal case. The general presumption enshrined under our Constitution that he enjoys the privilege of being an innocent or innocent of the crime which is attributed to him holds water. He is not under legal obligation to prove his innocence, Your Honor. It is the burden of the prosecution in this particular case, the prosecution, to prove that his guilt, and that is failure to indicate or enter into his cell the required matters that ought to be stated in there. I have not seen yet any document to the effect that a failure to state in a cell, Your Honor, on the part of the filer, especially impeachable officers, could be a ground for impeachment, Your Honor. Impeachment must be treated with caution, must be treated circumspectively, and not haphazardly or done as our government officials of the opposite persuasion may claim, Your Honor. And that brings me to the matter of, although I'm a little bit reluctant, Your Honor, our challenge against the validity of the impeachment complaint in this particular case. Why? Because when we examine the documents attached to the complaint, Your Honor, more particularly to the signature and verification and certification, we find nothing in there which states that the 188 members of our House of Representatives whose signature attached there were convened at any time prior to the certification in order to pass upon the probable cause aspect of the complaint, Your Honor. I hope, and in this connection, Your Honor, we are in total conformity with the jurisprudence on the point, more especially by the ponencia of Chief Justice Panganiban, Your Honor, where it on the issue of observance of due process during the initiation of impeachment, Your Honor. May I be allowed to read in part, Your Honor, for purposes of having them entered into the record. Fourth, during the oral argument, Senator Salonga and petitioners Francisco Chavez denounced the second impeachment complaint as violative of due process. They argued that by virtue merely of the endorsement of more than one-third of the members of the House of Representatives, the Chief Justice was immediately impeached without being afforded the twin requirements of notice and hearing. The proceedings were therefore null and void. And the Justice Panganiban then, who became Chief Justice, I said, I must agree. Going further with his ponentia, Your Honor, he further laid down the following dictum. The due process clause, Article 3 of the Constitution reads, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws enshrined in our Constitution, is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial, or otherwise. Citing Justice Mr. Bernas, the commentaries, and several cases, Your Honor. It is deemed, according to him, written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with notice and opportunity to be heard prior to being impeached, are also unconstitutional. Along this line, Your Honor, may I also bring to the attention of this Honorable Court the concurring opinion on the same subject, Your Honor, by the retired Justice Inares Santiago. And it runs this way, Your Honor. The impeachment complaint suffers yet from another serious flaw. As one of the amicus curiae, former Senate President Salonga pointed out, the signing of impeachment complaint by the purported one-third of the congressman was done without due process. The Chief Justice, against whom the complaint was brought, was not served with notice of the proceedings against him. No rule is better established under the due process clause of the Constitution than that which requires notice and opportunity to be heard before any person can be lawfully deprived of his right. Indeed, when the Constitution says no person shall be deprived of life, liberty, or property without due process of law, it means that every person shall be afforded the essential element of notice in any proceeding. Any act committed in violation of this due process must be declared null and void. With the citation, Your Honor. Now, I brought home to the attention of this Honorable Court, Your Honor, this particular jurisprudence on the point, because if we follow the proceedings that attended the filing of this case, Your Honor, I hope the prosecution and the government will pardon me for saying it. To us, although we may be charged as biased, Your Honor, we noticed the blitzkrieg maneuver that accompanied or clothed the filing of this information. True, there were allegedly a point presentation by the Honorable Lead Counsel at the time of the meeting of the congressman who signed the 188. But we do not notice any statement, or the statement relative to verification and certification is totally bankrupt of any statement to the effect that they assembled, they discussed this matter, and it was only after determining that there was really notice and proper opportunity for investigation was made that they came to the filing of this case and so on. My point is this, Your Honor. The number of the complainant, whether they be more than 200 congressmen affixing their signature, assuming their signature, the affixing of their signature, were voluntary and personal, that does not nullify the provision on due process, because it is a time-honored principle of our Constitution that no person shall be deprived of life, liberty, or property without due process of law. Now, if the impeachment complaint is filed by only by a member or by a private citizen with the endorsement of a member of the House of Representatives, the procedure enshrined is it must be acted upon by the Committee on Justice. There must be deliberation, and whatever the result of the deliberation, it is presented before the House in plenary session. Those are the only things that were dispensed with if the information or the impeachment complaint is filed by more than one-third of the members of the House, Your Honor. With that, we rest our case, Your Honor. We only pray, Your Honor, na sa aming pong pagdulog, sa kagalang-galang na hukumang ito sana po dumulog po kami sa poong may kapal. Hiniling namin kung maaari, tanglawan po ninyo ang pag-iisip, ang puso at damdamin ng mga senador na huwes na hahatol sa kasong ito. Sana po, umira lang buong katarungan sa ikaliligaya, hindi lamang ng impeachment court, hindi lamang ng nasa sakdal, kundi ng buong Republika ng Pilipinas. At sana po, ito'y maging mitya na para magkasundo ang buong nagkakaalit at lumigaya ang buong Pilipinas. Salamat po ng marami, Chief Justice.
Okay. Session suspended for 2 minutes before the
closing of the prosecution.
Before the closing,
Mr. President, may I move that we suspend for 5 minutes?
Thank you. Thank you.
5 minutes suspension.
After na lang daw po the Speaker Belmonte, yung press briefing. So, wala pa po muna.
May tanong po ako kay Deputy Speaker. Ano ba yung palusot? Ano ba yun? Congressman Sani, nahuli ka na ba nagpapalusot ng asawa mo?
Okay lang ba i-go ko na black pa? Kasi wala pa din si Portia.
Wala ba yung Senate film?
Okay lang, Sir Robert. I-go ko.
Thank you.